Hello, all you legal-minded friends. Could this case we are about to discuss have worldwide implications if you do not speak English and you do not understand the law and you are stopped by the police? We're going to look at a police body cam footage and discuss this case in Florida, and we'll review the differences in the UK. Let's first play a news clip to get us started.
Sergeant confronting the young man who tells the sergeant repeatedly he cannot speak English.
The confrontation became more aggressive until Aguilar Mendez was handcuffed. Moments later, the sergeant collapsed. He later died. Defense attorneys contend he died of a heart attack. We want to warn you, the body camera video we're about to show is hard to watch. News4 Jax reporter Marilyn Parker is joining us. She also has obtained documents from the defense. Marilyn, those documents shed some light on how Kunvovich died.
Yes, the state is charging Aguilar Mendez with aggravated manslaughter and violently resisting. Immigration attorneys tell me this won't be easy to prove, and we want to be clear. We're showing this video to simply be fair to both sides. This video is hard to watch for many reasons. Sergeant Michael Kunvovich, whose body camera we're watching, died after this situation. The man charged in his death, 18-year-old Virgilio Aguilar Mendez, doesn't speak English. Here's how it started.
Okay, why when I was driving around? Stop.
So I've stopped it there as the chap is trying to explain to the police officer where he is staying at the hotel. The officer has not been dispatched in connection to a complaint. He saw the chap walking in a parking lot and decided he wanted to question him. That is my understanding. In the UK, a police officer has reasonable grounds for suspicion, and they can stop and detain you in order to conduct a search. There should be a basis for that suspicion based on facts, information, and/or intelligence, which are relevant to the likelihood of finding an article of particular kinds.
Why when I was driving around? Stop. Okay, but why did you get up and walk away?
Huh?
When you saw me, you got up and walked away. Why?
Yeah.
Why?
But you meet me out here, you go for a little drink.
His responses aren't all that clear. We showed this video to an immigration attorney. But this person doesn't appear to be doing anything wrong from this. He's just standing there.
Right. I think there's going to be a lot of litigation as to whether there was a reasonable suspicion that he was committing a crime, was about to commit a crime, or had committed a crime.
So let me just explain what he's saying a little bit in more detail. The Florida law allows law enforcement who encounters someone they reasonably believe has committed a crime or is in violation of a local ordinance to temporarily detain the person and determine their identity, the circumstances around their presence at the location that led the officer to think that the person was involved in criminal activity.
Where are you staying? Sleeping?
He points to the Motel 8, and according to this defense motion, he left the motel to eat outside while on the phone with his mother.
Well, why aren't you eating inside? What? Okay, I've got something coming.
Kunvovich keeps asking him questions and then attempts to search him. There was no reason to search him in that moment.
If the officer has a reasonable cause to believe the individual is armed with a dangerous weapon, they can search to rule that out. However, if the person that's being searched does not consent to it, then just if you're that person, make it clear that you're not submitting voluntarily. But resisting is not a good idea, and in this case, we see that it has a very sad ending.
Asking him questions and then attempts to search him. There was no reason to search him in that moment.
Yeah, so if there's no reasonable suspicion that a crime occurred and there's no probable cause that he had a weapon, then you can't search him.
This is where it gets physical.
Don't walk away from me.
No, sorry.
Don't pull away from me.
So what is odd, and I just want to add this, is that the 4th District Court of Appeals made a decision in 2001. That case is called Sedell versus State, and the Florida State Attorney General agreed at the time. I believe it's only a 4-year term, but anyway, they agreed that an officer's bare suspicion of trespassing on a hunch that a person was trespassing and didn't belong in a certain area was not sufficient enough to initiate an investigatory stop and detention. So what is going on here?
Pull away from me.
More units arrive and Aguilar Mendez is tased several times, all while trying to explain that he doesn't speak English.
Lay on your stomach. I'm sorry, no speak English. Lay on your stomach.
So the rustling goes on quite a bit, and I think for about 6 minutes, the young man says that he doesn't speak English. He says it several times. They start to tase him several times. So many more officers come on scene. In the UK, if a suspect does not speak English, an interpreter should be arranged, and if that cannot be done, they should try to use non-verbal language to try to communicate, and at all times they should be de-escalating the situation. So I'm sure the defense is going to find out why de-escalation was not, done.
And Aguilar Mendez is tased several times, all while trying to explain that he doesn't speak English.
Lay on your stomach.
I'm sorry, no speak English.
Lay on your stomach.
Stop.
So he was found with a small pocket knife, well within the lawful limits for both Florida and the UK. But what I was surprised about was how many officers there were on the scene. I'm going to play it a little bit further than the news did, and you can find the full footage of the police body cam in the description linked below.
Hey, we're very familiar. Hey, we're very familiar. Hey, hey, we're very familiar.
The suspect or person charged, the young chap, was believed to be a teenager, 5'4", from Guatemala, who was staying at the Super 8 Hotel in St Augustine, Florida, with other farm workers. I do caution you to view at your own discretion, as it is long and it is very difficult to watch. So now we're going to look at what's happening next.
Moments after Aguilar Mendez is in handcuffs, Sergeant Kunvovich collapsed, then died at the hospital. The defense says he died of a heart attack. How will they carry out this aggravated manslaughter?
And they would have to establish that Mr. Aguilar Mendez, he knew or reasonably should have expected that his act would have caused the death. So that's going to be very difficult.
We're following. Witnesses were called today in the trial of a man who prosecutors say served a role in the death of St. Johns County Deputy Michael Kunvovich earlier this year. Witnesses testified today on Aguilar Mendez's competency to stand trial. He used an interpreter and a psychologist. And a psychologist said that Mendez does not fully understand the severity of his charges. The judge did not issue a ruling today and also pushed back a bond hearing until the competency ruling is made.
So pretty much the same would happen in England. One has to be competent before they can be accused of a crime. They have to understand what crime they're being accused of, and they have to be able to take part in their defense. So same is, would happen in the UK. So in this hearing, the defense, made an argument in the competency hearing that, he doesn't speak English, but another dialect of Guatemala, and his understanding of the law and what happened isn't very clear. And that could be because he could have head injuries from a car accident that happened a little while ago, and he didn't seek any, medical attention. They argued that he could have been born with a brain damage or other plausible causes, and it's hard to say. but there is a strong indication that he does not have the concepts of his legal rights. And, he mostly answers yes to all questions that he's asked because he doesn't understand, what's being asked of him. Even when there was an interpreter, he lacked the capacity to understand. So they don't believe he's competent to stand trial. The question would be, would he be able to learn or be trained to have to have the statutory requirements for competency in the future? So let's just listen to a bit of that.
And then we can revisit the intellectual disability. I do understand that typically for intellectual disability that what is required is a finding before the age of 18. We cannot do that. All of his records are from Guatemala. We have no recording of that information. We do have inconsistencies that appear to be based on language. Whether it's the numbers or the sequencing or nuances, his reporting of his social history is varied and confusing. Is that because he's intellectually disabled, or is that a function of his language? I don't know right now, and that's why the competency training would be helpful. So I'd ask the court to, without rehashing everything, because I know the court took notes and paid attention, I'd ask the court to find him incompetent, place him in the least restrictive, meaning his release, and allow for competency training with the appropriate agencies, and if need be, allowing the GMC to assist, not just with transportation, also with other issues that he would need for daily living. And to be clear, it's not just that Dr. Davis did not evaluate him for intellectual disability. He didn't do those follow-up questions in terms of how do you eat, how do you get to work. So for him to say that he can do these daily living functions is quite the stretch. And it's without an actual investigation as to how he's actually doing. And rightfully so, because he wasn't there to evaluate him for intellectual disability. His focus was mental illness. Thank you.
Thank you. Well, I disagree with the characterization that the counsel just made. Dr. Davis was there to do a competency evaluation. Whether that was mental illness or intellectual disability, it doesn't really matter. He's there to do a competency evaluation. What his testimony was, in general, was that he saw that in his, even with individuals who are intellectually disabled, they would at least retain some information. If there's some misunderstanding, you give them the information, you test them on their ability to retain that information, and he got worse, which raised a red flag with him consistently, regardless of whether he's intellectually disabled or not, that he was not putting forth his best effort. And because that red flag was risen time and time again during the evaluation, Dr. Davis came away with a conclusion that defendants did in fact could have the ability to retain the information and simply did not want to put forth the effort to provide his answers. And so it was his opinion. And he sat here through the testimony of the other two doctors, and despite their testimony, was not persuaded. It was still his opinion that the defendant was competent to proceed, and his inability to give appropriate answers to the questions that he was being asked, not necessarily. And there was some language issues, of course, but his opinion was that was primarily that he wasn't putting forth his best effort. Even if the court were to find that the defendant was incompetent to proceed, obviously it's got to make a determination of why. What's the basis of the incompetency? I think it's very clear from the experts the defense put on that it's intellectual disability. None of the experts testified that he had any sort of mental illness. That the ones that said that he was incompetent was based on intellectual disability. Dr. Leon, I think I asked her specifically the question, was he 2 standard deviations below the mean? Was he had deficits in adaptive functioning? Again, I would argue there's a question about that based on Dr. Davis' testimony. He's come to this country here illegally, which a lot of people who are perfectly highly intelligent would not do that because of how difficult that is. But
very briefly, Your Honor, that point of clarification that the GMC was not here offering competency training, but just to facilitate in terms of bringing him back and forth for transportation, if released, allowing him to be in close proximity to his family if the court allowed, if the court wanted him to stay in St Augustine, they would make provision for that in terms of providing housing, transportation, and training in terms of how to deal with or talk to teachers and things of that nature, that there are clear and distinct cultural differences between my client in his interaction with any government agency, and they can come alongside and help with that. But if the court did order competency training, that they could facilitate that meeting, bring him to the doctor, take him back.
And we're assuming that he's going to be released, which that's a pretty large assumption. So what could the court order, if the court goes along with this, what could the court order while he's in custody?
While he's in custody, right, because the reason I'm saying that is because the court knows that it's to do it to the least restrictive form.
But the least restrictive form, as we know it, is it regardless of what this court does, the federal government also has a hold on him. So he would not be released. So I'm asking again, other than releasing him to the public, what are the court's options?
And it's the court's position that competency has to be resolved first.
Well, what does the law say? Can you tell me?
It's my understanding, and I know that's...
Are the proceedings stayed until this determination can be made?
It's the understanding of counsel, yes, Your Honor. I'm not perfectly clear. It's just my understanding of competency is that I'm allowed to move forward with the motions that are not dispositive. And that's why I filed the motion seeking bond.
I believe that well, let me ask you this. Would it not require, for a bond hearing, some level of engagement with your client, from your client, as to that proceeding? That's my concern.
Yes.
So unless you can tell me that you could go forward without any level of engagement or participation by your client, I think that we know the answer to this.
Yes.
All right. I will certainly recognize that we need to get that bond hearing scheduled as quickly as possible. So I will think about this a little bit more. This is a complex situation, as we can all agree. So let me have a little bit of time to think about it, and then I will either reconvene to announce my ruling in open court, or I will issue a written order.
Yes, sir.
All right. Anything else from the state? Anything else from the defense?
No, sir.
All right. Court is adjourned.
If you're interested in this case, check out Legal Vices, as he will be discussing the powerful bond motion that will shed more light on this case. Legal Vices believes that this outcome will have far-reaching implications for the accused and the grieving family of the fallen officer. I have left his link below in the description area, so please check that out and subscribe to him. Hit that notification so that you know when he's going to be talking about this case and other great cases that he talks about. You know, I love to introduce you to great YouTube channels, so please check out Legal Vices. I'm going to leave you with this change.org petition. There is already over 500,000 signatures to release this young chap immediately. You can listen to what people are saying, and you can read comments. So please check that out. I will leave a link in the description area below. By leaving a comment, you may help someone else that will read your comment. And of course, I love to read all comments, as they are valued, and together we can be more informed. And this information may help you or someone you know. In the meantime, on this channel, you'll find a variety of playlists to suit every curiosity about the justice system. And we provide you with a visual to information and the process. Going through a legal worry is devastating, and the Who Knew and Why Me playlists are designed to help you or someone you know. So please like this video if you like this kind of content. Hit the subscribe button and the notification bell if you want to be notified when I'm going live or upload another video. I'm Karen Cole from Legal Minded Friends. Information is power, meaning if you know something, you can make decisions that are right for you.